Any other comments on governance? Yeah. Okay, Brian.
Consistent with what you were saying, I agree. We want to try and keep some flexibility in the governance. I agree with the fact about putting the geographic regions into the bylaws. The other suggestion I had the other day was having the capacity, I used the word co-op, but I gather that might be controversial, so appoint a couple of people as members. One of the things to make this work is that you're going to have people who are on the governing council who are really making the contribution. We don't want any people who are just there because they've been elected but they're not really active. So trying to give flexibility to the governance would mean that if there were some people who were particularly keen or had expertise which could be supplement what the governing council's members do, they could appoint them. You can put a cap on it, you know, maybe, I think it was suggested no more than 2, that's fine, that could be appointed. So just for the consideration of people is whether we want to have that capacity in addition to the people who are elected, that the governing council may from time to time appoint up to 2 members to serve on the governing council.
My recollection is that we agreed on the principle and that we volunteer you to write the text. Oh, you have it?
So my suggestion was you could do that by, in 6.2a, add a little 3, then you'd have 2 members who are appointed by the governing council under Article 6.2, and then I put BA, but just so that we could renumber. And then the subparagraph BA would be the governing council may, comma, from time to time, comma, appoint up to 2 members to serve on the governing council.
But I would, the only reason for giving the governing council such a power is in order to bring in people with special qualifications. So we should qualify that, because otherwise it will be just 2 more members. And in explaining your proposition, you justify it. So I think those criteria should be there. Okay, all right. Is there any opposition to this proposal? Here we agree on the principle, and Brian, you are going to give Nick Brian. So Brian will give Nick Brian a text, and we have already agreed on the principle. Any other comment? Mansoor.
6.2H. The word misconduct is rather strong because it will have a major bearing on our position back home. If we are removed as for misconduct, we'll have trouble back home too. So you want to use the word removal and misconduct with some other words because it'll have a bearing. We might not pay our dues and might be removed, and back home they might think that we've done something really major, and they might proceed against us at home. So I think for a judge, the word removal and misconduct might be a bit not in the correct taste, perhaps.
But are you suggesting that we judges don't misconduct?
No, certainly, but look at this misconduct. It says misconduct in the performance of official institute's duties. I mean,
yeah,
fine, but I mean...
No, here we are speaking about judges that, from the institute perspective, should not be members because they misbehaved. Of course, this needs to be qualified.
Put it to vote, I mean, how would they see this will have a major bearing on their position back home?
Well, this person will resign, I suppose, right? But don't we need to have some sort of qualification here? I mean, what do you propose?
I don't know. I'm just trying to say that...
I'm not afraid of the term misconduct, personally.
Fine. I mean, I just thought I'll just share that. If everybody's comfortable with misconduct, I'm okay. I mean, I thought it was a bit harsh.
Justin?
I don't know, I'm happy to,
Can I,
yeah.
I mean, I slightly agree with Manso. I think this is very heavy. You know, we're talking about a global institute which is designed to facilitate training. I don't suppose it's going to have enormous funds, and the opportunities for anything that would be described as judicial misconduct, I suspect, are very limited. And I do think it's slightly heavy having these sort of strong disciplinary provisions in this sort of document, but that's just my view.
So let's find a synonym, because we have to say that people,
But you don't have to mention
small,
why, right?
medium,
You could say
or
they'd be
big,
removed.
this will be a human institution.
That's true, but
It will not be different from any other institution.
One solution could be that once any such thing happens, the governing body could replace and substitute the member. And we achieve the objective, and that person goes home. But to say that he's removed from his conduct is, you know.
Yeah. You know, to me, we need to have a rationale for removing somebody.
Could
You don't
say-
just
could you
remove
say-
somebody because you don't like the person.
You could just say for good reason.
Somebody for good
for
reason.
good cause.
Yeah.
Okay, Justice Emmanuel, yes, that could be a possibility for good cause, for,
Good reason.
yeah. So, Emmanuel
for
and then De Leon.
I totally agree with my colleagues that misconduct requires a lot of other disciplinary procedures, including coming up with an independent body from the council. So maybe if we just try and water it down to underperformance of official institute, maybe.
Yes, that would be,
Underperformance if you're not performing to the
yeah,
level.
is that
I don't know.
acceptable?
Oh, why don't we do the usual? Why don't we take it to the bylaws?
Okay,
You
I
know,
think
yeah.
that's a good,
Yeah.
and then we think about it. Yeah, good suggestion. Yeah, that's the technique we're using. Is that okay? We remove misconduct and we say for reasons as established in the bylaws.
If we could say that the removal of the governing council members from governing council for reasons, for good cause and for reasons to be recorded, may be removed from the membership.
But instead of finding the right words, perhaps it's better to just mention the possibility of being removed for good causes as established, something like this, by the bylaws.
Correct, because reasons recorded, Justice Kumar, if they hit the media in India, would be a problem.
Yeah. Yeah.
So, as you've written it here, it's only in the performance of official institute duties or in your profession, so you wouldn't cover any personal violations, people who
So you want
molest
to even
children?
we have in all this discussion here with the limit scope. Would you like to expand it?
So, no, I would think if you want to put it in the bylaws, you could just say removal for good cause.
Yeah, that's it.
And then
That's
just
the
leave
idea.
it. And-
That's the idea. That's the
Okay.
idea. Say again? As the bylaws, yeah. Okay. Yeah. De Leon.
We discussed earlier on the use of the word removal on page 6, that is about governing council members. And we decided that since removal is also used in 5.6, removal of ordinary members of the institute, so we said we also use the same term, removal, for part of any other acceptable term. So we just use the word removal for members and then also for governing council members. Same term, removal.
Even though I feel that the word removal is also strong, if I don't know how the others feel about it, I think it should be replaced or substituted, because removal also carries a very strong message. It's as if disciplinary proceedings have taken and somebody's been removed. I'm just placing it before the judges because how they would look at it in their own jurisdiction. In my jurisdiction, the word removal would have a consequence.
So what's the verb that you use?
Replace or substitute. The governing council might substitute a member, and we leave it to that. I mean, there has to be some grace about it too. I mean, we don't have to really nail the
So instead
bar.
of removal, we can say replaced or substitute?
We use the term cessation also at one point. Cease to be a member. Just an option.
Yeah. Okay, so we are asking Nick Briner to incorporate those comments. So we are going to make a reference to the bylaws, but keeping here the possibility of replacement or cessation. Cessation seems to be...
Cessation of membership.
Yeah, cessation of membership, yeah. Yeah. Mm. Yeah. And Kuma is also proposing that we should have two clauses, one for officers and another one for members. I think it's a good idea too. Yeah. Any other comment? Okay, so let's now move to partnerships, Article 7. Nicole?
Given that we've now reduced substantially institutional membership, it would be good to include in partnerships some of the judicial schools, associations and academies, I think, to specifically put those in there. As, originally they were intended to service the judges, and now the way they will do that is not through membership but through partnership. But I think it would be good to put that wording in under the article on partnerships. So it's moving the wording from 5.2a, describing judicial schools, association, academies and other similar organisations, and placing it in Article 7 on partnerships.
But don't you think that those judicial schools that are separated from the judiciary are already included here?
Well, it just says non-governmental
No,
organisations.
it says international, regional, national, subnational, and non-governmental organizations. We could say governmental and non-governmental.
Yes, if we say
Yeah,
that,
Nick?
that is broad enough.
Yeah,
Okay.
yeah, Nick Briner. So we need to add governmental and non-governmental. I agree. It's the first time I read it.
In which provision?
Well, it's Article 7. When we say international, regional, national, subnational, and governmental and non-governmental organizations. Any other comment? Yes, Brian.
I just want to pick up the suggestion from the Kenyan judge that one of the important ways of improving the capacity of judges is also to work in partnership with the legal profession. And so I think we could include here legal professional bodies, because they may not be considered to be a non-governmental organisation, but I think that would be something which we should have the power to work in partnership with. So I'd just suggest adding after governmental organisations and legal professional bodies.
Can I just add, if we say legal professional bodies, that might refer to bar associations and all. So member of bar associations would automatically, then, I mean, all lawyers will be included. I mean, should we say legal professional bodies or legal professionals?
I was thinking the bodies, because you work with those organisations rather than individuals.
Yeah. Any opposition to this? If not, approved. Can we move now to Article 8? It's pretty straightforward. Finances. Comments? And before you, and while you think, let me ask Mike Wilson and Luke Lovrison if you have finalized the text on that particular point that I have forgotten what the point was.
Thank you for remembering that. Luke and I had a rich conversation during the break, and Luke gave me a bit more understanding about the manner in which he was suggesting the participation of public prosecutors. And I think that Brian's suggestion perhaps would cover the concerns that we were discussing, and which basically I think, Luke, was to make sure that we include legal organizations that have a commitment to the environment. And you were speaking, I think, about public prosecutors in particular. My concern was that we didn't want to leave out public defenders. So, Luke, let me ask you about this language, and maybe Brian's will cover it as well. But in that vein, in that spirit, the suggested language was, the Institute shall seek partnerships with legal bodies working in the field of environmental law, including public prosecutors and public defenders.
Should we use the verb shall or may?
May.
Yeah.
I think there are two different things. The first is the membership, and we discussed already judicial schools in continental Europe. In most countries, this judicial school work both for judges and public prosecutors. So that's already covered there. What I meant is our colleagues who have a session, a parallel session here, is they should not be members but I think some of the training material, etc., is useful for them as it is. So maybe these are, let's say, special partners, and in continental Europe, if public prosecutors are not bringing the cases, then the judges are not dealing with the cases because we don't have the possibility to bring our own cases. So that's in that spirit that I was suggesting. Mentioning public prosecutors, public defenders, I think it's a good idea, but I leave it to you two.
Well, we probably will not meet consensus on this unless we find the precise language, because we have to have a language that addresses a particular situation. And the particular situation is in those countries in which the office of the Attorney General doesn't exist as a separate entity from the judiciary. And someone goes into this very broad institution and can say, well, I'll be a public prosecutor, and then 4 years later, or 5 years later, now I'm tired of being public prosecutor, I'll go and decide cases. So I think that's what you had in mind, right, Luke? Do you have a specific provision for that in the bylaws of the European Union?
No, but we have a cooperation agreement now. There are two networks.
Yeah, but couldn't we do the same? Have cooperation agreements without having...
Yes, but that's what I mean with partnership. I don't mean that there should be member, etc. I think when you are doing capacity building, as we do in Europe, often you will do it at the same time for the judges and the public prosecutors. That's everything. That's all what I'm saying, and it's an important it's an important group because they bring the cases. We cannot bring ourselves the cases. That's all. So I am not saying that they should be member, etc. But a lot of the work we will do will be useful for them also.
A question. Do you think, Luke, that with the additional language that Brian proposed and we have already accepted, how was it, Brian, cooperation with the legal profession bodies? Yeah. So in this case, we have already addressed when we strengthen and refine this provision. Okay. So on the finances, the institutions that we are working with. So far, for 3 years, we have been financed. In India, we continue doing the same. Kuma has just asked a good question that I would like to share with you. He asked, who is going to finance us? I said, until we are fully incorporated, the same institutions, meaning us, that have financed us for 3 years and a half. We have had so many meetings in different parts of the world, India, Europe, here, Central America, the Organization of American States in Washington, D.C. But for the moment, we are not discussing the incorporation. Yeah. Yeah. No, but I just wanted to. Okay. Yes, Mansoor?
Just a comment on finances. I think B, C, D are okay. A could be a bylaw thing because we don't know where the chief financial officer is coming in from, who's appointing him. It's a micro provision. We're just generally talking about financial regulation and all that, which is fine with B, C, D. And this, who's going to run and manage and who's the financial officer, can be a bylaw matter. I mean, he just comes in from somewhere.
No, but here we are not giving the details. We just thought it would be necessary to identify clearly in the charter that we judges should not be afraid of being a member of the governing council, since we don't like doing financial stuff. And if, this is not clear, and there is a risk of I being selected to be, the financial officer of a judicial organization, I don't want to be elected. So that was the idea. But then in the bylaws, we are going to specify precisely how this will work. Is that acceptable to you? Okay. So, Article 8 approved. Let's go to Article 9, and I need to make a comment. The text you have there intentionally does not mention the venue of the Secretariat, because in selecting the Secretariat, we need to make sure that whomever and wherever, whomever volunteers to host the Secretariat, and wherever this is, that we have a firm commitment for at least 5 years, because we can't be moving the Secretariat every year. And there will be need to re-identify the best place for this Secretariat. We faced the same problem with the IUCN Academy. We were in Ottawa for 12 years, right, Nick? Around 12 years, and now the Secretariat has moved from Ottawa to New York, Maryland, in a joint agreement between two different law schools. And here is a bit more complicated because we might want to have the secretariat with a very well-established court that is, has the commitment to support financially and with human resources this small secretariat. So in 9.2, it's stated that the Governing Council shall determine the location for the secretariat. The Council's decision in this regard should take into account the privileges and immunities provided by the jurisdiction in which the secretariat is located, and other consideration as deemed relevant for ensuring the functioning of the institute. And we could, in the bylaws, spell out other requirements. And B, upon the formation of the institute, the interim governing council may choose a temporary location for the secretariat until a long-term location can be found. And this clause, of course, is based on the assumption that here we would not establish yet the governing council, but we will do it in our next meeting. And then in that meeting, we would select the venue.
Yeah.
I think Professor Bharat Desai would like to speak.
Two small things which I can chip in, that while the secretariat is being located, two legal implications will arise. One is the host institutional arrangement, and second is the host country arrangement. That may be that.
Yeah, but that's a decision that we need a decision about a decision.
Yeah.
Whether we are going to take this decision here or whether it's premature to take this decision here.
And also,
I would submit that it's premature to take this decision here.
But while the entire process for establishment of the Judicial Institute takes place, there has to be some servicing arm which will cater to the
Yes, the same servicing that we have had and led us here. We have nothing. And in spite of having nothing, being just a group of fragmented, very committed people, we are here.
So some reference could be there that pending the arrangement or till the Judicial Institute formally comes into being, till the Governing Council takes a decision.
But it is there in A. It is in A when it mentions an interim, I'm sorry, in B. Any other comment here? If not, then let's go to the bylaws. And we have now put so much on.
It'll be a separate chapter.
Now the bylaws. So Nick Briner, you thought your task would be over with the charter. It's just the beginning. We need immediately to begin working on the bylaws.